Good afternoon, Daniel Bornstein, Bornstein Law. Thank you very, very much for making the effort to attend this webinar. We are in a very interesting time in the life of real estate investors throughout California, and it's particularly thorny in the Bay Area. My hope today is that within an hour, you'll have a better understanding of what's going on. I'm, of course, not going to be able to give you everything, but a survey of what I consider to be the most compelling information that you need, whether you're an investor in San Francisco, the East Bay, or other parts of the Bay Area that addresses some of the core issues that we are facing right now as we trend out of the pandemic, which President Biden stated we were no longer in the pandemic, and yet we still have the residue of a lot of the prohibitions or limitations on what can and cannot be done as a owner of rental property. So please buckle your seatbelt, get yourself ready, and let's have a wonderful learning experience. The agenda for today will be we're going to talk about San Francisco's continuing protections of rent owed, our new registry requirements in San Francisco, our new pre-notice notice, the 10-day warning notice, an update on Alameda County eviction moratorium, the litigation challenging it, and some of the current reasons by which you can pursue an eviction. I'm going to give a quick overview of the state law for those of you who have property in, for instance, Walnut Creek and other locations that don't have a particular local jurisdictional statute, rent increases throughout the Bay Area, how to recover rent debt after COVID and now, discuss briefly buyout agreements, and hopefully after we've covered all of that, you're in a better position to understand some of the obstacles you face in managing or overseeing your rental property. So let's jump in on San Francisco at this moment. So many of you are calling my office and saying, Mr. Bornstein, the eviction moratorium is over, we're free to go. And I have to say, wait a second, that's not exactly the case. And we'll talk about Alameda County. Many of you who are watching the news know LA County had an eviction moratorium, and it's trending out of the moratorium by the first of the year. San Francisco did the following. There was the state moratorium, and then San Francisco immediately enacted a local protection that became effective July 1st. The protection is as follows. For non-payment of rent cases, where the rent debt became due on or after July 1st, 2022, a tenant has an available defense to the non-payment of rent case, alleging a financial hardship related to COVID. That doesn't mean you can't serve the 3-day notice. It doesn't mean I can't prepare a 3-day notice demanding July, August, September rent. If I serve that 3-day notice and the tenant doesn't pay the rent, I do have the ability to file a eviction lawsuit. However, one of the defenses to the eviction lawsuit is that the tenant suffered a hardship related to COVID during this period, and therefore they cannot lose their tenancy. What does this mean? It means, rest assured, if you're going forward with the non-payment of rent in San Francisco for July, August, September, and future rent, you may end up in a situation where you're at court, the defendant files an answer, asserts a COVID-related defense, and you are checked. You won't be able to recover possession of your unit. However, it is my suggestion that we still demand rent in a 3-day notice, and we still pursue the unlawful detainer action because this tenant who hasn't paid you July, August, September rent may owe you even more rent in the past. And what I'm finding at the court in San Francisco is that the eviction lawsuit doesn't necessarily result in a vacancy, but it results in you recovering some of that unpaid debt that has accumulated since the inception of the COVID pandemic, because San Francisco has third-party local organizations that will help cover that rent debt. We know state rent debt, you are entitled to recover up to 18 months of COVID-related rent debt. But some of you have tenants who owe you 24 months of unpaid rent or even more. And so I am still a proponent of demanding the rent, knowing that a tenant may still have a defense, filing the lawsuit, because in the end, the tenant gets a free attorney and they work with the third party to get into a settlement that allows you to recoup past rent debt from a third party. That's important. I would not pursue this if we're talking about $2,000 to $5,000, but if you have larger rent debt and you need to get that money into your pocket, using the eviction action is an available remedy to recoup some of that debt. Remember, under the current San Francisco iteration of their moratorium, you're not allowed to impose late fees and or penalties on rent debt, but there are no particular special notice requirements for demanding rent. But I want to caution you, you want to have an attorney prepare those 3-day notices. They're tricky. You have to have the San Francisco Rent Board 2-page attachment, and most people can lose a non-payment of rent case, not because the tenant has paid you the rent, because you know they didn't. It's because your notice is improperly drafted. So you still have to be careful about how you handle the rent debt. Most importantly, it's my recommendation that you proceed with non-payment of rent cases at this point in time. The court in San Francisco is open. It's better functioning than it did 8 months ago. Cases are getting sent to trial. And so we're moving and shifting away from the pandemic, which of course is lovely and hopeful. Another issue for you San Francisco investors. Remember, we have this rule about intermediate length occupancy. San Francisco was besieged with Airbnb units. San Francisco was besieged with short-term rentals, and the city cracked down on it. Remember, you need to get an intermediate length occupancy license in order to enter into leases that are less than a year. What does this mean? Landlords must offer a 12-month lease in alignment with the rent ordinance. Less than a 12-month lease, not permitted unless you have an intermediate length occupancy unit, and you've got to get a license for it. Now, what does that mean? It means landlords and property managers, their hands are tied. What if a tenant says, I want to sign a 6-month lease? It's a multi-unit property. It's 5 units. Tenant says, look, I'm okay. I'm going to be here for 6 months. I want to sign a 6-month lease. Under the intermediate length occupancy status statute, you're not permitted to sign a 6-month lease. However, what we are recommending you do is sign a 12-month lease and specifically have an addendum in the lease that allows a tenant on 30 days notice to terminate the lease early. If it's a 6-month lease, you say on or after the 5th month of the lease, the tenant shall have the absolute right to, upon 30 days notice, end the lease without penalty. So there's ways around the statute, but I want you to understand the statute is out there. It was an attempt to try to get owners to stop corporate short-term rentals, and now we're stuck with this year requirement for properties in San Francisco. For more information on this, just email me. Again, my email is daniel@bornstein.law. Many people are unfamiliar with this and may be ignoring it. Ignoring the law creates risk for you. So by all means, if you have a situation where you're going to offer a unit for less than 12 months, contact me, because you've got to be careful. Sign the lease for 12 months, but have an escape clause embedded in the lease that allows a tenant early termination. New legislation. Oakland has had this type of pre-notice notice requirement for some time. San Francisco introduced this within the last 5 months. Here's the rule. For breach of leases or nuisance cases, before you can serve a 3-day notice to cure or quit, you now must serve a pre-notice warning, a 10-day warning letter. And so where we have a tenant who is engaging in nuisance conduct, partying at all hours of the night, music at all hours of the night, loitering inside the unit or inside the building of his friends and guests because they're partying like crazy. Before you can serve a 3-day notice to cure or quit for nuisance, you must first provide a 10-day warning letter. If during that 10-day period, the tenant stops the nuisance behavior, the matter's over. If during the 10-day notice period, the tenant continues to engage in partying that's a nuisance, only then can you segue in to the 3-day notice period. Got it? There is exemptions to this requirement where the tenant is causing an imminent risk of physical harm to persons or property. So we don't have to, if a tenant beats someone up, serve them a 10-day notice warning them that their behavior is egregious and to stop it. We can segue into a 3-day notice to quit immediately, because imminent risk of physical harm where someone is engaged in violence, you don't have to provide that warning letter first. However, for those situations where we do not have imminent risk of physical harm to persons or property, the 10-day warning notice is required. The rent board has a draft of the warning notice for your use. I don't think it's ideal. If you want a warning letter to be served upon your tenants, let's say they brought a pet without permission and it's not a comfort or service animal, it's a violation of your lease agreement, it's not an imminent risk of physical harm to persons or property, you've got to serve the 10-day warning letter. Let's say a tenant is subletting without permission. It doesn't expose someone to imminent risk of physical harm to persons or property, and so you've got to send the 10-day notice warning letter first. That's how it works. Where we have breach of lease covenants, where we have nuisance conduct, we are now obligated to serve a 10-day warning letter. What is this likely to do in San Francisco? Well, it will elongate the process by which a tenant has to cure their violations. It will likely reduce evictions because tenants have an extra step before they're faced with evictions, and it's likely to increase the cost of legal fees for landlords and property managers and you folks, because now you have an added step before you perfect your right to file the unlawful detainer action. When in doubt, I'm happy to help you out. I'm happy to make an assessment of what we're dealing with is whether we've got an imminent risk of physical harm to persons or property. If someone's engaging in arson, 3-day notice. If someone's vandalized the building by taking a bat and breaking the windows, 3-day notice. However, if someone is engaging in partying or noise, that is an imminent risk. You've now got to serve the warning letter. If you don't serve the warning letter and you proceed to a 3-day notice and you file an eviction action, you could lose the case because you did not follow the now embedded statutory obligation of serving that pre-warning letter first. When in doubt, contact me. I'm happy to help you out. New rule, new regulation. out of 100 San Francisco real estate investors, maybe 20 are aware of this. Now you are aware of it, and now you are educated. Congratulate yourself for being a part of this important webinar. Rent registry. So San Francisco is going to be complying and collecting data about rental units. Remember, if you own 10-unit building, your reporting requirements occurred July 1st. If you haven't done this yet, do it now. For those who are in ownership of fewer than 10 units, March 1st, and every March thereafter, you're going to be having to update the rent registry. We will be providing a link to the San Francisco Rent Board's registry and a template that you can use, and we will send that information out to you as a link in a e-blast. But for now, be advised, if you've been sleeping throughout the COVID pandemic, not staying aware of new rules and regulations, you've got to make sure that if you own a building, 10 units or more, it's got to have provided the rent board the rent registry data. And if you don't, you will be impacted by an inability to impose rent increases or banked rent increases. So there is a significant penalty for ignoring the registry requirements. Alameda County. We are still in the midst of a pernicious eviction moratorium, and Alameda County is an outlier throughout the state, and it has the most draconian protections at this point anywhere. What does it mean that Alameda has an eviction moratorium? You're not even entitled to serve a 3-day notice to pay rent or quit right now in Alameda County. San Francisco, you can, and we're proceeding with non-payment of rent evictions. In Alameda County, you can't. The moratorium will remain in effect 60 days after the supervisors call an end to the public health emergency. The only exceptions, an owner is proceeding with an Ellis Act, and I'm getting more and more calls from owners who have accrued huge debt and they have no solution other than to consider going out of the rental market. Another exception is that the building was red tagged, and that's not ideal. That would be if there was a terrible fire in your building and it's no longer safe to be in there. You can proceed with an eviction. And then we have one other exemption, is where the continued occupants pose an imminent threat to health and safety. That's where we've got arson, violence, drug dealing. That type of behavior, we're still able to proceed despite the Alameda eviction moratorium. I want you to remember though, the moratorium does not apply where we have a licensee like a family member occupying a unit. So if I give permission of a family member to live in a unit because they're my family and I no longer want them to live there, they never paid rent, there is no lease agreement, they were given the right to live there because I gave them permission, that's not a tenancy. The moratorium does not cover those type of situations, and we have proceeded for these type of terminations or removals. And we have also proceeded in Alameda County for those terrible situations where we have drug dealing, violence, arson, anything like that. We've still been able to proceed. It's just more cumbersome. Remember, there are other locations that have enacted their own moratorium, but most importantly for Alameda County, you need to recognize that the moratorium remains in place until the local public health emergency is ended, and the moratorium will end 60 days thereafter. However, many of you know that the supervisors continue to preclude opening and revisiting a change to the eviction moratorium. but a lawsuit's been filed. And the lawsuit's been filed by a group of interested owners who own property in Alameda County. And there is a hearing on September 29th to determine whether the moratorium will be struck down. The arguments are, as I've listed, the moratorium has imposed a hardship on rental providers for almost 2.5 years. Renters and occupants need not prove COVID-related distress to avoid eviction. And what that means is you can't serve a 3-day notice to pay rent or quit, despite the fact that your client or your tenant is a CEO of a multi-billion-dollar company in Alameda County who chose not to pay the rent. It's inherently difficult to evict at this point in time. And so these moratoriums are fundamentally unfair, and the Alameda moratorium is arbitrarily placing an unfair burden on housing providers. Cross your fingers, hope that as of September 29th, a decision is rendered after the hearing to end this nonsense. If it is ended, then I will immediately have a new webinar, and we will talk about the repercussions of the moratorium being ended and discuss what are the next steps to take. For now, though, the moratorium is in place. September 29th is an important date, but we have no clarity as to what the court will do. And I am absolutely apprehensive to guess. Never in my 26-year career as an attorney representing owners have I been confronted with people calling me with $40,000, $50,000, $35,000, $70,000 of accrued rent debt in Alameda, asking me what to do. And after a little bit of dialogue, and then they ask me again what to do, my answer at times have been to pray, because at this point, I don't have a solution to the problem. I can't use the court to remove the tenant. The tenant is not cooperating. They're not seeking and have not sought third-party rent relief, and they're sitting inside your unit accumulating debt. Or you have tenants who are subletting, and because it's not an imminent threat to health and safety, I can't act upon it. You bought a property during COVID and you wanted to do an owner move and eviction in the property. Your broker, real estate agent did not inform you that Alameda has an eviction moratorium. You bought a property, you can't move in, you're paying a mortgage, you're paying rent in your current location. I can't do anything about it. The option of a buyout is available, and we'll talk about that. But with this eviction moratorium in place, I'm without many options, and that is inherently problematic for you and for me, because I am so empathetic to the crisis that many of you have faced, and I don't have easy solutions. Again, let's hope that the court, in its wisdom, decides that this moratorium has elongated well past its shelf life, and they immediately direct the supervisors to end this nonsense. Statewide protections. Remember, many of my clients have purchased or have multi-unit properties in San Francisco. They've moved over to Contra Costa County. They've moved down to Santa Clara County, and now we're segueing into other counties throughout the state that don't have its own rent ordinance or just cause eviction rules. And where we have those multi-unit properties, we're looking at AB 1482, which is state rent control and state just cause eviction rules. Remember, if you own a property in San Francisco, you're likely going to be subject to San Francisco just cause eviction rules and San Francisco rent control if it's a multi-unit property. There are exceptions. If you own a property in Berkeley, if you own a property in Oakland, you're going to be subject to the local ordinance typically. However, if you own property outside of those jurisdictions, you're likely going to be subject to the state rent control just cause eviction rules. Let's quickly go through them. Remember, we have annual rent increases capped at 5% plus the rate of inflation, no more than 10%, whichever is lower. Landlords must demonstrate or show a just cause in order to evict a tenant if they've been in the property 12 months or less. Single family homes, condominium units are exempt generally, unless owned by a corporation, a real estate investment trust, or an LLC where one member of the LLC is a corporation. For the state ordinance, it does not apply to new construction, 15 years or less. So if you're fortunate and you built a building and it's only 5 years old and you're in Walnut Creek and it's a beautiful 20-unit building, well, you got 10 more years before you're subject to state rent control and state just cause eviction rules. Remember, the protections only apply to tenants who are in occupancy for 12 months or more. And under state law, there's no prohibition against signing a shorter lease. So if I'm a savvy real estate investor, I may consider signing 10-month leases in my Walnut Creek multi-unit property, because a 10-month lease doesn't trigger rent control or just cause eviction rules, and allows me to actually get a sense of whether I have a quality tenant who I want to keep in the unit, or I have someone who I would prefer to transition out. And if it's at the 10-month period and it's only a 10-month lease, there's nothing under the state ordinance that precludes you from keeping them in possession of the unit. For no fault evictions, and we'll go through this, it's a simplified relocation payment. In San Francisco, we may know that owner move-in evictions can cost you upwards of $25,000 in relocation payments. Under the state law, which is less pernicious, less difficult, we're looking at the equivalent of 1 month rent for no fault terminations. Under the state law, these are the general basic just causes that you can proceed upon: failure to pay rent, breach of lease, nuisance, waste, failure to execute a new lease agreement after you've been given one, criminal activity, assignment, subletting, precluding an owner from accessing the unit after written request, which is you post a 24-hour notice and they don't provide access, using the premises for an unlawful purpose, such as a house of prostitution or something that stigmatizes the property, a drug dealing location, removing an employee from the premises or a licensee, and then where a tenant gives you notice that they're vacating and subsequently doesn't vacate. That is not available in San Francisco, Berkeley, or Oakland, where a tenant gives notice and then rescinds notice. Here, under the state ordinance, you're perfectly entitled to proceed and accept and expect a tenant who gives you notice that they're terminating the tenancy. If they don't leave, you're entitled to proceed with the unlawful detainer action. The no fault evictions or tenancy terminations that are contemplated under state law are as follows. And when we say it's no fault, it means that it's no fault of the tenant that they're being asked to vacate. The first one is owner or relative move-in. The second one is withdrawal of the rental unit from the rental market, which is akin to the Ellis Act, where you go out of the rental business. The third one is intent to demolish the unit or substantially remodel the unit, and it has to be a substantial remodel. It's not a paint job inside the unit. Substantial remodel. For those of you who are contemplating a no-fault termination on a substantial remodel, email me and I'll give you the exact language of the ordinance where it specifies what is going to be deemed a substantial remodel. And then the last one is where you may be red tagged, or you have a demolition, or you need to remove tenants because of a government entity informing you that the building is not safe. So at this point in time, those are the no faults. And what do we know about the no faults? When you serve a termination on a no fault under state law, you must give the tenant the equivalent of 1 month's rent or credit them 1 month's rent. So if it's a 60-day notice, the 60th month, the second month would not need to be paid by the tenant. This is state law. If you are having to choose between state law and local just cause eviction rules, state law is much less cumbersome, much easier. And that means for those of you who are simply fed up with the strictures of a local jurisdiction such as Berkeley, Oakland, San Francisco, you're free to invest in other locations throughout the state that have a less cumbersome state just cause eviction rules. And also yearly rent increases between 5 to 10% are much more attractive than what we have locally, where, for instance, in Oakland, we're limited at this point to 3% yearly increases. And we segue into increases. Rent increases. Remember, these are limits imposed on landlords as we are subject to local or state ordinances. Rents have ticked up a bit in the Bay Area. However, they have not caught up to pre-pandemic levels. Remember, if your unit is rent controlled, you've got to make sure you understand the rules and regulations of the particular jurisdiction. Also, single-family homes and condominium units typically are exempt from local rent control and state rent control rules. So if you happen to own a single-family home and a condominium unit, you are typically free from the strictures of rent regulation. However, when in doubt, go on the internet, Google your city, and look up the ordinance to make sure, or even easier, contact me and I'll be glad to have a dialogue with you about what are the rules and regulations for your particular unit. When I first started the practice representing owners in the Bay Area, we looked at the San Francisco rent ordinance, the Oakland rent ordinance, the Berkeley rent ordinance. Now there are 15 throughout the Bay Area. People ask me about a rent ordinance and now I have to take a deep breath because the ordinances are so tricky. I don't have that skill set to remember each and every ordinance and what the rules are. I actually have to go to the ordinance to make sure I'm giving you proper information. As I get older as well, my memory needs reinforcement by looking at the ordinance, and that's a reflection of simply elderly status. I'm not there yet, but we are all trending in that direction. So we take and accept the repercussions of living for a life of working in this industry and recognizing that the complexity requires support and research, and this is tricky. Let's look at it. San Francisco, we have allowable increases of 2.3%. Oakland has a new CPI, but they've limited rent increases at 3%. Berkeley, Antioch, Richmond, Hayward, San Leandro. I don't need to go over all of this with you, but for those of you who have property in any of these locations, you want to make sure you're familiar with the ordinance. And remember, Antioch just voted in the rent control ordinance. We've got in Oakland an election where there's a ballot measure that will in fact impact all Oakland property to make all Oakland property subject to just cause eviction rules. For those of you who have bought a property excited that it's exempt from from Oakland's just cause eviction rules, well, you may be horribly disappointed after November when all of a sudden the rules come in. And all I can tell you is that the amount of new information coming through on real estate and landlord tenant law is enormous. I've never faced the amount of new rules and regulations that are structuring a landlord-tenant relationship, and they're jurisdictionally specific. Mountain View, Los Gatos, East Palo Alto. When you consider imposing a rent increase, you need to know, can the rent increases be banked, where you can go back in time and add the yearly percentages into the increase? Is the owner in good graces with the rent board, which harkens back to the beginning of this? Did the owner properly provide the information for the rent registry in San Francisco? How often can rents be raised? How is the base rent calculated? Are you with a great tenant and it may be better not to impose a rent increase during this COVID pandemic? And then master tenants who have subtenants and whether they're overcharging their subtenants. There are many considerations when deciding to impose an increase. One, you have to make sure that you're doing it correctly, that your paperwork is done correctly, that you know what rules and regulations you need to follow. And then there's the bigger issue is you can impose a rent increase on a great tenant. And if there's vacancies throughout the community, they may decide to actually go and find another place at a lower price point, and you kick yourself in the pants for having imposed the rent increase. So be smart. I always suggest to you, landlord-tenant law, there's a lot of law, but there's a lot of social engineering and strategy involved. And I, as a real estate investor myself, as a broker who has a property management company, and as a landlord attorney, I'm always able to discuss strategy with you. So it's not simply a rote recitation of the law. It's really a dynamic assessment of what are your goals, what do we hope to accomplish, and what do we think would be prudent. And when we do that, we come to good decision making. And I often believe that dialoguing with someone about what you're hoping to accomplish allows you to make good decisions, which is prudent, especially in this difficult time. Remember, single family homes, condominium units, you want to make sure you talk with me so you know whether or not an increase is permitted. And remember, increases over 10% in California on 90 days notice, increases under 10% are on 30 days notice. To add insult to injury, the state has issued emergencies regarding fires, flooding, drought, heat, COVID. And when we are in a state of an emergency, there is an anti-price gouging statute that precludes rent increases in excess of 10%. You need to be familiar with the perpetual state of emergencies that have existed, and you need to know which counties are subject to a state of emergency. And to the extent you are faced with a state of emergency, you've got to be careful about your rent increases. They may not be permitted. When in doubt, contact me. I'll provide you a link to assess it. And again, I can't predict the future. If there's a big wildfire close to the Bay Area next week, we may be put into a state of emergency for our counties, and we will have limitations on the increases that are permitted. And this applies across the board, both condos, single family homes, and multi-unit properties. Now, what are we going to do? Many of you have COVID-related rent debt. There are ways to recover the lost income, or better yet, there are ways to get a judgment to at least have against a tenant for not having paid you COVID rent debt. Assuming the moratorium are over in all jurisdictions, you can proceed with a demand in small claims court and or superior court. Small claims court for COVID debt does not have a monetary jurisdictional limit. But for you folks who may be carrying $40,000, $50,000 of rent debt, you may decide that small claims court, where there is no attorney representation, where the small claims court judge may be a volunteer attorney playing judge for the day, a pro tem judge, and you may decide that the debt is so large that even though you can go to small claims for that debt, you're better off in regular court, where there are no limitations regarding attorney representation, and you have a more slow, deliberative process. It's more expensive, but at least you have the ability to feel more confident that you'll be able to at least get the judgment you're entitled for. At any point in time, if you're considering pursuing a debt through a demand, 3-day notice to pay rent or quit in San Francisco, or you're considering proceeding in a small claims case and or Superior Court, I'm happy to discuss it with you. I will say for you, the greatest leverage to recover possession of your unit or the debt is the preparation and service of a 3-day notice to pay rent or quit. Tenants understand that paying the rent or losing housing is a very serious consequence for ignoring a demand for payment. A small claims case where a landlord will get a judgment against you does not result in you losing your housing. It just results in a piece of paper that says the tenant owes you the money. A judgment can be collectible or it cannot, but it doesn't displace a tenant from a unit. So when deciding what to do, please contact me. We may decide a hybrid approach where we seek in small claims some of the past COVID debt, but we proceed with a 3-day notice for current debt. That type of confluence or hybrid is something I'm happy to talk with you. And remember, there's a big asterisk. We can't go to court on an eviction in Alameda for non-payment of rent yet. So you may consider going to small claims court, but again, that may not get you the leverage you're hoping for. We had hoped SB 847 would have passed and it would have allowed us to recover more tenant rent debt through third-party sources. However, that's not the case. The measure failed. All things in Sacramento point to a protection of tenants, typically at the expense of landlords. And I can only tell you right now that the most important thing for all of you is to stay focused on the law, stay abreast of it in the news, and when in doubt, contact an attorney, get onto my email blasts so that you're kept up to date about all of the new changes in the laws that are forthcoming. I hope that as the pandemic dissipates, we have a deep, long breather and we're not subject to the volume of new laws in this area that are making it challenging for you and of course challenging for myself. Now, I always end by saying this. If you can avoid court, if you can avoid litigation and accomplish your goal of a voluntary move out of a tenant who's not paying you rent, that's the path of least resistance. During the COVID pandemic, my office was less busy at the court, but just as busy preparing voluntary agreements where a tenant gives up possession in exchange for some benefit. The beauty of this is that you're not just getting quote unquote cash for keys, you're getting a voluntary move out and you're also getting a release of claims so as the tenant vacates, they're not going to be able to sue you thereafter. If you have to spend $10,000 on an attorney to proceed with the non-payment of rent eviction on a tenant who has terrible credit and is unlikely to ever pay back your judgment, would it be easier to pay the tenant $2,500 to move out in 60 days and you're done with the tenant? And the answer is yes. When we do the simple math, $10,000 to pay for an attorney to deal with an eviction or $2,500 to pay the tenant to move out, it's easy. We are always thinking strategically. When people ask me, well, what should I do? I say, what we want to do is accomplish your goal as fast and as inexpensive as possible, taking into account attorney fees, time, and risk. Generally, tenant buyout agreements are an appropriate choice and they're usually prudent. They may be a little bit more expensive than you anticipated, but you accomplish your goal. Be advised, whether you're in the city of Alameda, Berkeley, Oakland, San Francisco, there are different rules and protocols you must follow to complete a proper code compliant buyout agreement. There's not something you pull off Nolo Press and think you've got it. Contact my office if you're inclined to consider negotiating a deal with the tenant, and I can tell you how to do it. I can coach you on it, and then I prepare the proper agreement so that it's code compliant for the particular jurisdiction you're in. This is important. We got so busy, I have one attorney handling and drafting buyout agreements all the time throughout the Bay Area because we find it the path of least resistance and the smartest way to accomplish your goal of a vacancy if that is in fact what you're hoping to do. Getting involved with the court is risky, costly, expensive, and time consuming. A buyout agreement is more efficient. So with that stated, I wanted to let you know that there is ballot initiatives in November. Tenants do have the right to organize in San Francisco particularly and create quote unquote tenant unions. There is state legislation brewing at all times. Stay informed. I have found the best real estate agents, the best property management companies, the best individual real estate investors are those who stay abreast of the law. That doesn't mean you have a complete understanding of it. It means you know what you know what you don't know, and you are always accessing someone with that knowledge in order to steer you correctly. The people who don't stay informed of what's happening, whether it's current events in real estate, landlord-tenant law, or simply new legislation, they are a bull in a china shop. They create liability for themselves because of their ignorance, not because they have bad character, but because they simply are not aware of the dangerous behavior they're engaging in because they simply don't know the law. So with that stated, I want to congratulate all of you for attending and participating in the webinar. If you do have questions, of course, email me. If I can answer them quickly, I'll be glad to do so. If it does necessitate a meeting, I'll let you know. I always let my clients know when I believe I need to charge or whether I don't. Most importantly, I'm available. It's my privilege to provide you information. It's my responsibility to you to keep you informed, and it's an absolute pleasure to do so. So with that, I want to thank you very much. I want you to know that we have a team of attorneys in the office. We speak Spanish, we speak Cantonese, we have interpreters, and we're able to help you out. Don't be shy. Email me and be a partner with me so we can continue to make good decisions and maximize the value of your real estate investments, and most importantly, be outstanding housing providers for the community of people throughout the Bay Area. That's what we're proud about, and that's what we do. So with that, I wanted to thank you very much and wish you all the best. And I hope as we trend to the fall and get into the holiday season, the pandemic is behind us and we are now in a situation where all of our lives improve tremendously. Thank you very much. Daniel Bornstein, Bornstein Law.